Molly Fox.
All right, what are we doing?
All right, welcome to the part of court that looks quiet on paper, but is actually loaded with consequences. This is a bond fight wrapped inside a recovery court conversation, and those two things don't always play nice together. Defense is basically saying, Judge, we've adjourned this a bunch, we're talking resolutions, and we want Mrs. Fox back out on bond so she can lock in family support and actually follow through with treatment. That sounds reasonable, until you remember what bond is supposed to do. Protect the public, protect the case, and make sure the defendant shows up and follows conditions. The moment drugs are in the conversation, cocaine specifically, judges get extremely wary of hope as a plan. Courts don't want promises, they want a structure, a verified program, a confirmed placement, a clear treatment path, and accountability built in. That's why you'll hear the judge push back like, okay, but what do you want me to actually do today? Because adjourn and release without a concrete treatment plan can look like the court turning the key and just hoping the engine fixes itself. And pay attention to the chess match here. Recovery court can be a lifeline, but it also changes leverage in plea negotiations. They're still not even sure what the plea would be if she enters recovery court, so the judge is hearing, we want bond back, we want time, and we'll figure out the deal later. That's a tough sell unless the court sees a real safety net already in place.
Well, Your Honor, this is a PCC conference, and we've had many adjournments, but what I would like to see happen today is that the court would reinstate Ms. Fox's bond and let her get out. And I would say that Jacob Kennedy and I have had many discussions about resolution here, but we haven't really come to a conclusion. And he sent me the paperwork on the recovery court, which I discussed with Molly Fox. I went to visit her on Sunday and talked to her about it. And we went through some of the responsibilities and what would be expected of her if she could be accepted in such a court. I believe that she could do that, but only if she has strong family support. So I urged her to, what I would like is for her to get out so that she can talk to the family members, which are, in my opinion, their involvement and support is absolutely essential for her to be able to complete the recovery court program. The other matter is we have never really come to a conclusion as to what the plea would be if she were to go into the recovery court. So I would like to have an adjournment of the PCC, but I also would like to have her released again on bond so that she can do these things and come to some kind of conclusion.
Well,
I thought he was
stop using cocaine.
Well, of course she does. Absolutely. And she did complete the first 8 weeks successfully of the Dawn Farm program. She doesn't, that's the other thing. She doesn't know whether they would let her back into the program or
They should actually be able to re-enroll.
Okay, so what do you want me to do with, you want this adjourned?
Well, yes, but I wanted to be adjourned with a release of her from custody and go back on the bond if possible. Because she's had kind of...
I don't negotiate that way, but that's okay. I don't know that I'll release her. I don't know what you want me to do.
Well, as I did make out an adjournment paper.
Do people have a position on bond?
Yes, Your Honor. In this case, involved a situation where the defendant was intoxicated, and that's why she failed the test. And then while she was going on, I don't think that a release is appropriate without a rigid substance abuse treatment plan in place, which there is not.
Well, I'm informed that the Dawn Farm program would let her back in. I don't know for sure. I can't represent to the court that that's possible, but she seems to think it is. And that's a pretty, she was attending AANA once or twice a week. She was doing a group program, and she did that for 8 weeks successfully. And then, she had the incident where she used cocaine again.
Well, 2 incidents.
2 incidents, sorry.
Yeah. Probably more because there's a lot of abnormal creatinine she was using. So the issue from the court standpoint is this. I am not going to release her or change her bond until there's something in place so that she's at least receiving some treatment or something along those lines or some program. It's not going to happen. Give you time to put that in place or to try to figure out what that's going to be. And I'd suggest that you talk with the prosecutor's office and try to work something out that is structured for this individual. So your motion for bond modification is denied. I will adjourn this matter to June 26, 2025, 9 a.m.
That is the judge drawing a bright, unmistakable line. No treatment plan, no bond modification. And legally, this is exactly how judges protect themselves and the process. Because once the court loosens conditions and something goes wrong, everyone looks back at the judge like, why did you let them out without safeguards? Notice the logic. The defense isn't being punished for asking. The request is being denied because it's incomplete. The judge is basically saying, I'm not gambling with the community's safety and the defendant's stability on a maybe. Also catch the practical roadmap Judge Simpson gives. Confirm a program, then talk to the prosecutor, then bring it back as a motion. That's not a shutdown. That's instructions. It tells you the court is open to movement. But only if the defense can prove there's something real waiting on the other side of the jail door, like Dawn Farm actually confirming re-entry, a restart date, or a structured program.
Bonding.
Your Honor, just for my own information, if I were able to determine that the Dawn program would let her back in or let her restart or whatever, would that suffice from the court's point of view?
Here's what I'd suggest. If you were to confirm that there would be something in place for her treatment, I'd suggest that you get with the prosecutor's office, see if the two of you come to some type of an agreement. You can file a motion, I'll hear it, or we'll hear it on the 26th. Okay?
Thank you, Your Honor.
Thank you.
Good afternoon, Rob Jacob on behalf of my client, Dejan. Would you state your name, Dejan?
Dejan West.
Judge, thank you for the bench conference. Because of that conference, I spoke with the family. It's my understanding the court's loath to keep his PR bond. I talked to the dad. He would ask the court if it would consider a $10,000, 10% bond to post. Again, just Judge, he's on a tether. He's back in school. He's not had any alcohol. He's done with all these incidents, and he'll stay away from the victim. And I would just ask the court to consider if it's going to post a bond, let it be 10,000, 10%.
I'll let people make their motion.
And Your Honor, at this time, we would be re-requesting our original request of $50,000 cash surety. In this case, the defendant went to the victim's residence after being told that he was not welcome there and not to come over. He was walking around the house and the victim heard him outside and heard him say, "Fuck this, I'm going to jail, I'm going for a reason," before he kicked in the door.
That line is chilling because it's not just bad judgment, it's premeditation vibes. The prosecutor is painting a narrative of escalation, told not to come over, prowling around the house, then verbalizing something that sounds like intent. I'm going to jail and going for a reason. And then forcing entry. In bond arguments, the court isn't deciding guilt beyond a reasonable doubt, but the judge absolutely evaluates risk. Danger to victims, risk of retaliation, and likelihood of obeying conditions. And when the facts include children present and threats like, "Now I'm going to kill him," the court hears a safety problem first and everything else second. Defense tries the standard mitigation package. Tether, school, no alcohol, living with dad, no violations so far. That can matter. Judges do credit compliance, but it doesn't erase the underlying allegations. It's basically, he's behaving now. But what does the alleged behavior say about what he might do under stress?
The victim, who was his ex, one of the victims, grabbed a bat. He walked past her to go to the other victim who was sitting in the couch. She then hit him with the bat. He continued on and began attacking the other resident in the house. There were children present in the house, although they were still present in the house. He was then assaulting this other male there, punching him while being hit with the bat. He still didn't stop. The victim then had to grab a knife and stab the defendant to try to get him to leave the house. That didn't even stop him. After being one of the victims heard him say, "He made me bleed. Now I'm going to kill him," and talking about the victim he had been attacking. Eventually, he did leave the house, but I believe the bond that was set at arraignment as a PR bond was an abuse of discretion. And at this time, we would be requesting a $50,000 cash surety bond for this case.
Judge, just for briefly, it's pretty apparent that alcohol influenced a lot of these dumb decisions he made that day. He had been living there. He went over to get some of his stuff when the incident occurred. I don't condone what happened, but again, Judge, he's on tether. He's living with his father, who's present in court. He's not had any violations, and I would just ask the court to keep a minimal bond.
I guess the great difficulty is that while the defendant's out, at least at this point, we don't have any violations of the conditions that are set. But in terms of the factual allegations of this case, does the defendant have a prior criminal history?
Yes, there's a previous conviction that he was on height of probation for a malicious destruction of personal property, 200 to 1,000 out of, I believe, 14B.
So at the time of this alleged offense, he's on probation.
I believe so, height of probation.
Judge, my client says no, but
I just literally probably about a month ago just got off probation. I had to pay the rest of my fees and then I was done.
Can we check? That's a difference.
Oh, Your Honor, his case was closed on May 15th, so he had just recently finished.
So he had just come off of probation.
Because this happened on May 25th, Your Honor, of this year.
10 days after he's off probation.
This is the judge's wait, what moment, and it's a big credibility and risk factor. The court is hearing prior conviction on probation until May 15th, alleged offense May 25th, 10 days later. Even if the defense frames it as relationship went bad and alcohol didn't help, the timeline screams instability. Judges look at probation as a structured environment. If someone can't stay out of trouble immediately after supervision ends, it suggests the external controls were doing the work, not the person's judgment. Also notice how the court handles a factual dispute in real time. Defense says he was off probation about a month ago. Prosecutor says May 15th, and the court verifies. That matters for bond because judges hate guessing. The judge wants the clean timeline before setting conditions, and once it's confirmed, it becomes part of the rationale.
Anything else?
no, Judge. Again, it was just a relationship that went bad. He went to get some of his stuff. Alcohol didn't help. But that being said, I'm asking you to keep it 10 grand at 10%.
Well, I am going to grant the people's motion, Mr. Allen. I don't, given the circumstances, I guess the defendant has at least shown while he's been out at this point that he's able to conduct himself appropriately. So I'm taking that into consideration. But I think that the initial setting of the bond in this case was an abuse of discretion given the circumstances. I will set the defendant and the fact that the defendant just got off probationary status 10 days prior to this, which again, I don't quite get why he would get himself potentially involved in something like this. I will set the defendant's bond at $20,000. I'm not going to make it a cash or surety. I'm going to give him 10% privilege on that if it can be posted. So it's $20,000, 10%.
Here's the compromise, and it's a very judge math moment. The prosecutor asked for a $50,000 cash bond, which means pay the full amount to get out. Defense asked for $10,000 at 10%, which means you post 10% up front, typically $1,000, and the full amount hangs over you if you violate. Judge Simpson lands in the middle. $20,000 with 10% privilege, so about $2,000 to post, but with a higher stake and a louder warning. Legally, this does two things at once. It increases accountability without instantly pricing the defendant out of release, and the judge openly says why. The defendant has been out with no violations so far, so the court is giving credit for compliance. But the judge also calls the initial PR bond an abuse of discretion given the alleged facts, meaning the first bond was too lenient for the risk. This is the court correcting its own system. We should have taken this more seriously at arraignment.
At this point, all other conditions remain in effect.
Thank you, Judge. Can we adjourn this matter to the 26th? I was just retained last night, and I imagine there's a lot of discovery.
Probable cause conference will be adjourned June 26, 2025, 9 a.m. or as your invite indicates. Thank you.
Ken Madadish on behalf of Ms. Henderson, who is appearing by Zoom. Ms. Henderson, can you please state your name for the record?
Arlene Henderson.
Thank you.
You're welcome.
Requesting an adjournment.
Yes, Your Honor. We are going to refer her to our AIM division and to continue plea negotiations with the prosecutor's office.
How long is she going to be in Wayne County Jail? Does she know?
A while. I believe they're doing a competency report there, so it's going to take a minute.
So
we can adjourn it out.
So there's a comp on her case there?
There, yes. I'm debating whether I need to talk to
Counsel approach.
the seniors in our office.
Counsel approach.
Yeah.
Or you can keep talking. Counsel approach.
Oh, counsel approach.
I told you to be quiet. All you gotta do is talk a lot. Shut up and be quiet.
This is one of those moments that reminds you courtrooms are human spaces, not just legal machines. You've got a Zoom defendant, the court is discussing competency and adjournments, and then suddenly you hear what sounds like real-life chaos bleeding into the proceeding. Someone talking to kids, scolding them, snacks, crackers, the whole thing. The judge's reaction is blunt because the court record matters. When someone is appearing by Zoom, the court still expects courtroom behavior. Quiet environment, focus, no side conversations. And the timing is important. They're talking about competency, meaning whether a person is mentally able to understand proceedings and assist counsel. Courts take that seriously because if competency is in question, the whole case pauses. So when the audio turns into a messy home scene, it doesn't automatically prove anything legally, but it does affect perception. Is this person stable, organized, and taking the process seriously?
Nobody got time for all that stuff. Y'all see me in court. Y'all want to play like two little kids. Y'all not getting no snack when we get back home. You hear me? Do you hear me too? Josiah, it's not funny. Don't say nothing else. They're gonna be back on here in a minute. I was gonna give y'all some crackers. I'm gonna give you anything. You know? It's cold. I'm freezing.
Okay. On this case, what I will do is I'll adjourn the probable cause conference, understanding that I may get a request for a competency or forensic evaluation to coincide with the one in Wayne County, but I'll adjourn this to, we'll just do July 10th initially, and then we'll see where we are.
Thank you, Your Honor.
July 10th, 2025, 9 a.m. On continue.
Thank you.
Court calls case of the People versus Aaron Fromm.
Sherilyn Foster Tucker on behalf of Aaron Fromm.
Aaron Fromm?
And Your Honor, we're just requesting a brief adjournment to review discovery.
Probable cause conference will be June 17th, 2025, 9 a.m. That's Tuesday. Bond will continue.
Thank you, Your Honor.
Good day, sir.
Okay.
What is it?
Court.
Hi, say your name for the record. My name is Siobhan Benson.
No finding yet.
Right behind you.
All right.
Your Honor, today is a time and date set.
Your name, ma'am?
Oh, my name is Siobhan Benson.
Thank you. All right. Yes. Go ahead.
Today is a time and date set for a competency hearing and all matters and the people are in receipt of a report from Center for Forensic Psychiatry dated May 15th, 2027, authored by Candace Shield, PhD. And we would stipulate to the entry of that report and ask that the court make a finding based on that.
Any other evidence for the defense?
I apologize, Your Honor. You asked if there was, Your Honor, we have had an opportunity to review the report as well. We are going to stipulate to the findings in the report, and as per the probable cause conference, Judge, we're asking for an adjournment as we continue our investigation.
All right. For the purposes of the competency, the defendant, based upon the review of the report, the defendant is competent, will be found competent to stand trial. Specifically, the court would find that the defendant can understand the nature and objects of the proceedings against her, of the charges against her, and can rationally assist in her defense. Therefore, the defendant is deemed. I will set a probable cause conference then. Would the 26th work for you?
We will make it work, Judge.
June 26th, 2025, 9 a.m.
Thank you, Your Honor.
Thank you.
Bond will continue.
I also want to expose these people because they're lying on me. I'm not no demon. I'm not no monster. These people were hurting my daughter. They were sexually assaulting my child.
This is the emotional eruption that changes the temperature instantly, and the court's response, "You'll have an opportunity," is the judge trying to keep the process from turning into a free-for-all. Here's the key legal point. Even if someone believes something horrific happened, the courtroom still runs on procedure. The judge can't litigate brand new allegations mid-hearing, especially when the purpose of the moment is competency stipulations, scheduling, counts, and evaluation orders. But from a viewer standpoint, you can feel why this is powerful. The defendant is framing themselves as persecuted and reacting like the system is covering something up. That kind of statement can point in multiple directions: trauma, desperation, instability, or strategy, and courts have to be careful. That's exactly why you see forensic evaluation language and competency structure in this section of the transcript. The court is trying to determine, can this defendant participate rationally, understand what's happening, and work with counsel?
You'll have an opportunity to address
It's too much. I'm not no demon. They hurt my baby and they're hiding this. They're covering it up. The state of Michigan is hiding and covering this up. They hurt my child and I'm gonna
Thank you.
Releasing me a charge too.
They must have nice ears. Must have nice ears.
All right. So taking care of that part. Also, just because of the counting of the counts, at this time, the people are moving to dismiss count 3.
Correct, Your Honor.
There's no objection from defense. Dismiss count 3.
Don't talk to me tomorrow.
And then you're requesting a forensic evaluation.
Yes, Judge, I am.
All right. Forensic evaluation is ordered. I'll set a competency hearing for August 28th, 2025, 9
If I can address bond.
9 a.m. Yes, go ahead.
Come to our attention, Your Honor, that the defendant has made 18 complete calls to the victim since being arraigned. In these calls, the first calls his mother wants to do a throwaway call to connect the victim in, and then eventually gets a hold of the victim. And he's telling her he loves her, he wants to get back together with her. At this time, I'm going to be asking for his phone calls to be revoked because on top of the 18 completed calls, he has 124 total attempts, including those complete calls. So at this time, I'm going to be asking that his phone privileges be revoked.
Yeah, I'd ask that not happen. I think he understands now not to make any calls. I don't want him to be cut off from his family.
Okay. Well, you request a hearing on this, but I mean, after you listen to the calls, but he's supposed to have no contact with it. That's the third number.
And I'm very concerned that he's calling his mom and that was going to be called to try to make a three-way call.
Which is going to be also a violation of the bond. And this time, defendant's phone privileges are hereby ordered revoked. In all other respects, his bond will continue.
This is a classic bond conditions have teeth moment. The prosecution lays out the alleged violations: 18 completed calls, 124 attempts, using mom to try to create a three-way call, and the target is the victim, despite a no-contact condition. That's not a technical slip. That's the exact behavior no-contact orders are designed to stop, and the judge's focus is tight. Even indirect contact, even third-party contact, even attempted contact can violate bond. The court is protecting the victim and the integrity of the case. Defense tries the common argument: don't cut him off from family. Courts do care about family contact, especially for mental health and stability, but judges weigh that against the risk of manipulation and harassment. The phrase about three-way calling is a big deal because it shows intent to bypass the rules, not accidental dialing, so the judge chooses a targeted sanction: revoke phone privileges, but keep bond otherwise. That's strategic punishment. The court is saying, I'm not jailing you right now, but I'm removing the tool you're abusing.
Thank you.
Across this docket, you just watched 3 different court problems play out, and Judge Simpson handled each with a consistent theme: structure over vibes. In the first matter, bond modification was denied because recovery talk is not a treatment plan. The court wasn't refusing hope, it was refusing uncertainty. The judge made it clear the path forward is verification. Confirm program placement, negotiate with the prosecutor, then bring a real motion back. That's how courts balance rehabilitation with public safety. In the second matter, the bond decision turned on risk indicators: the alleged home invasion-style facts, children present, threats, and the timing: 10 days off probation. Judge Simpson increased bond to $20,000 with 10% privilege, explaining both sides. Credit for compliance so far, but calling the initial PR bond too lenient given the allegations. That is the court recalibrating conditions to match the seriousness of the case without automatically going to the harshest option. And in the final portion, the phone privilege revocation shows the court enforcing no-contact rules in a precise way. Bond can continue, but privileges can be cut when someone tries to work around restrictions, especially through third parties. The broader implication is simple: the court is willing to keep people in the community when they comply, but it will clamp down fast when conditions are treated like suggestions. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.